Hello and welcome to the Law School Policy Review podcast. Our topic for today is Indigenizing International Law for Multi-Species Justice. Our guest for today is Paulo Ilich Bacca.
And we're really honored to have you, sir, for this conversation today. And I know this been taken like a lot since while we've initiated this concept note, but we're grateful we're here today to talk on indigenizing international law for multi-species justice in this regard. Do you have any questions for us before we begin, or should we just dive down into the podcast?
Thank you for having me. It is a pleasure, and yeah, I think we can start.
It is our honor to have you on the podcast. For our listeners, just a brief description of Dr. Bacca.
Dr. Bacca currently serves as Deputy Director of the Justiciary and Professor at Javeriana University. His academic background spans law and ethnography. He holds a law degree from the National University of Columbia and a PhD in ethnography from the University of Kent. He has also been a Fulbright Scholar at Georgetown and a postdoctoral researcher funded by the European Research Council.
Also, sir, just a slight note, none of us can really speak Spanish, so please excuse our pronunciations. We will try our best to.
It's fine, Actually, English is not my language, so sorry for that as well.
I think that really ties in with our podcast. We're talking about indigenizing law. So we're all speaking in a language that was given to us by the colonizers, and it's none of our native language or mother language. So I think that's also interesting. Our the reason we're having this conversation right now is in context of the July 2025 International Court of Justice advisory opinion on climate change.
The July 25 advisory opinion on climate change has been called a vindication for vulnerable states. However, the opinion reproduces the same structural asymmetries that have defined international environmental law since Stockholm 1972. It grants formal equality in theory while overlooking the vulnerabilities of global south and small island developing states in practice. These nations face the most devastating effects of climate change despite contributing only a fraction of historic emissions.
Uh, we've been elated to know about your work, which deals with this problem precisely that we're having today. So you draw on, say, Colombian indigenous movements, Amazonian and Andean cosmologies, and that is what you precisely call indigenizing international law for multi-species justice. We know and we are privy to the fact that you've spent multiple years asking this harder question, and you do not merely ask how the global south can better use international law. Instead, you ask whether international law as currently constituted is fit for the purpose at all. And what would it take for us, or what it take for international law to change it?
Yes, thank you very much again. And indeed, my research question and what I have been trying to answer is why we as Western scholars cannot be able to translate our own language through the language of indigenous cosmologies. So in a way, in my own perspective and my own personal experience, I learned English very late in my life when I was 28, and it was a hard process because at the beginning, for example, my grammar works quite well, but I wasn't an idiomatic speaker because I was thinking in Spanish. And sometimes it sounds strange for native speakers, although the grammar works. And being able to immerse myself in Anglo-Saxon environments suddenly changed my mind. And at some point, I don't know how, I was able of dreaming in English. And it's a practical example, of how a culture can change you, I'm very different when I'm talking in my own language. Even my behavior, changed. And the exercise, it is quite the same. When I used to work with indigenous peoples, I'm fascinated by their words and cosmologies. And they told me to change the very concepts of international law through indigenous cosmologies. And it happened when I started to work within the National Indigenous Organization of Colombia, because they asked me to analyze the concept of genocide in terms of criminal international law. It was a field that at that moment was unfamiliar to me. I wasn't an expert on criminal law. I was very much involved on human rights and indigenous people rights from the perspective of international standards. And I immersed myself in criminal international law, but suddenly the indigenous leaders explained me their own interpretation about criminal law standards through their cosmologies. And that marks, um, um, a core moment in my intellectual history, because they push me, within their boundaries, and in a way ask me to interpret international law and criminal international law through the history of the indigenous movements here in Colombia, and then working on the field in the Amazon and in the Andean region, I started to understand how indigenous peoples have been able to use international law to their own struggles in order to keep their own cosmologies. So the exercise that was born at that moment, almost 20 years ago, was to try to understand international law and constitutional law through indigenous cosmologies. So in a way, it's a kind of inverse translation. When I'm talking in English, you as native speaker can think that probably in my translation, the English is losing something from its very soul. But I can see that the other way around. Probably through my Spanish, the English language is gaining something that it doesn't have. So mainly, that is the exercise.
Correct, Professor. That really helps us to set the context. You gave an example of how indigenous communities had their own interpretation of what genocide meant under the Rome Statute or under the International Criminal Court. But Professor, we know that all of these statutes or all of these languages, the textual provisions are drafted in ivory towers at the very best. People who are not privy to, the problems or the hardships of indigenous communities at best. So it is a Western construct to that effect that, say, developing countries or indigenous communities are not part of the decision-making process to that effect. So how do we see that changing, or what efforts can we take, or what is the scholarly discourse in this context? If you could just elaborate on that.
Yes, actually, indigenous movements, grassroots, and organizations have been doing that kind of exercise since colonial times. When the very discourse of international law start at the beginning of the 15th and 16th century, during the process of the colonization of the Americas, The debates were, for example, whether or not or the lands of indigenous peoples here in Latin America have an owner or not, or whether or not they have soul or not. That were the first debates in terms of international law. So international law play a role um, in the colonization of the Americas. And indigenous peoples um, not only criticize the framework of international law, but, under, but they understood that they could use this framework to claim for their rights, which is a very interesting paradox that it is grounded in practices of resistance. When the colonizer appropriates the language and the word of the colonized, he thinks that he's imposing their language. But the thing is that the colonized are able to transform and reappropriate the language of the colonizer. That is why the colonizers first learn the language of indigenous peoples to impose Spanish. And it happens the same, in the United States. Colonizers learn English, indigenous languages in order to impose English. In that sense, the process of appropriation and reappropriation is very complex. And indigenous peoples, have been able to go to the United Nations and to claim, for example, for self-determination. They were able to drive the first treaties on indigenous rights, and then the 2007 declaration on indigenous rights in the language of international law. But on the field, they use that language to keep their own language, their own jurisprudences, their own cosmologies. So they have been doing that exercise for centuries. What I have been trying to do with the proposal of indigenizing international law for multi-species justice is to reappropriate the very concepts of indigenous cosmologies to think about international law. For example, if for indigenous peoples, mountains and rivers are sources of law, how we can approach international law using this kind of language, how we can make a translation of the rules that indigenous peoples take from their relationship with mountains and rivers in order to transform the very framework of environmental international law. So that is the kind of exercise that I have been trying to drive, but it is an exercise that indigenous peoples have been doing for centuries. So in a way, I conceive myself as a diplomat and as a translator of the words that I have been able to to have a journey and to try to transform the field in which I have been working in the last years.
Yes, so your work pushes back against a long tradition where indigenous norms are treated as maybe custom, tradition, or culture, but not exactly law. So, where would this structural resistance to recognizing indigenous law come from? And what do you think has to change in legal education or even the courts for that recognition to become real and tangible?
Yeah, I think that is very important, to start changing our own sources of knowledge. And in that sense, for example, Gayatri Chakrabarti Spivak in India, have been doing so for um, for many years. We think that, for example, the only way to express ourselves in academia is writing. And writing, we understand that as, for example, books and articles, and in terms of law, constitutions, uh, and rulings. But what happens is that in other cultural traditions that many times belong to our nation states, there are different sources of writing. For example, dreaming could be um, a source of law. In the desert of La Guajira, in the north part of Colombia, um, indigenous communities, Guayú indigenous peoples, use dreaming as a way to make interpretations about a law, and to make, for example, biocultural indicators to fight against climate change. So that kind of intercultural dialogue, it is key to transform legal education. Indigenous peoples have been doing that with our laws. They have been attending law schools. They have become magistrates and judges of the courts here in Colombia, but in other contexts as well. So they have been very generous in the sense that they have been very open-minded to our concepts, or the concept of the Western tradition, um, to use them for their own struggle, even acknowledging that Western law has many amazing concepts and things. For example, if we think about a feminist theory, that is a Western background that can invigorate indigenous people traditions. And indigenous women have been working with that Western tradition in order to invigorate their rights. So why we cannot do the same? Why we cannot to take indigenous cosmologies to think about the rights of nature, for example, and to expand the concept of environmental law to a multi-species justice, in which the relationship between humans and not humans and spirits can bring possibilities to expand in a creative manner the very framework of international law.
That is actually a very fair point of cultural blending within legal education, which surely helps. You also talk about how what is happening to indigenous people in Colombia and elsewhere constitutes genocide by ecological means. Can you please shed some light on how that would happen, and explain the connection between, say, destruction of a river or forest and genocide?
Yes, well, the Colombian Indigenous Organization, ONIG, um, have been working on indigenous genocide, not only to think about indigenous extinction, but also trying to catalyze important doctrinal reflections on genocide by ecological means and indigenous ontological self-determination. So in the first scenario, as Rob Nixon has argued impoverished communities today are increasingly subjected to forms of displacement without movement, for example. It has been exemplified here in Colombia in the case of the Embera Catillo nation. And this expanded understanding of displacement, rather than being limited to physical relocation of people from their homelands, refers to the degradation and loss of land and resources that sustain them, leaving, leaving communities effectively stranded in environments that no longer support life as they once did. In that sense, displacement operates not only through physical expulsion, but through the gradual erosion of the ecological conditions that sustain life, culture, and territorial belonging. In the second instance, as Colombian ethnographer Daniel Ruiz have shown, indigenous organizations has forcefully demonstrated that territory cannot be reduced to a physical enclosure or bounded spatial category. Rather, it encompasses multiple interdependent ontological realities. So, indigenous territories are thus better understood as complex relational networks that include both human and non-human beings, which together co-produce the conditions of life and knowledge. So this relational ontology challenges the epistemic hierarchies embedded in Western legal and political thought, which tend to separate nature from culture, subject from object, and law from life itself. So by affirming the territoriality of these relational words, indigenous organizations advance a conception of a multi-species justice that recognizes that agency and rights of non-human entities, while also enacting epistemic justice through the validation of indigenous modes of knowing, governing, and inhabiting their biocultural landscape. So territory is not merely a space to be owned or administered, but a living, sentient field of reciprocal obligations and shared existence. So, in this context, to give you a practical example, the idea of rivers as veins of water, for example, becomes especially powerful. These narratives are not only about nature, they express the rules that make life possible. Over time, I came to understand that this relationship with water can also be read as a form of law, as a source of law. For many indigenous peoples, rivers are living beings embedded in dense webs of relations where water listens and speaks. So to defend a river is to defend an entire world.
Correct, correct. Professor, when you talked about, say, territory and how relationship with indigenous community transcends territory, and we should view this from a relational ontological lens per se. The first phrase that came to my mind was transboundary harm. So if we see what developed countries are doing today, so indigenous communities usually have some animal which they have some deep bond to, which have now gone extinct. Correct. Now, what these developed countries are doing, they're taking some currently living threatened species and they are taking fossils of the extinct species, and then possibly they're trying to revive those extinct species back. We saw the dire wolf de-extinction that took place in the US, which is, and many other similar projects that are going on. But coming to indigenous communities and multi-species justice in that case, because we don't know what these extinct species have to come for nature of a rivers for that example in the present context, because they've gone extinct a long while back. So questions arise with respect to trophic cascade, questions arise with respect to transboundary harm, and considering the ICJ opinion with respect to climate change, which crystallized the duty to not cause transboundary harm as customary international law, how do we see this crystallizing towards indigenous communities justice and multi-species justice in a broader context?
Yeah, well, it's a very hard and difficult question that pose ethical and political concerns. I think that we are experiencing uh, a moment in history where the relationship between law and science and technology is key. And the problem is that law sometimes, the developments of law sometimes are very slowly. And instead, science and technology goes their developments goes very quickly. So uh, I think that a good place to start, because I don't have an answer, is being very clear about, for example, a credit, authorship, and intellectual ownership, because this example that you um, are mentioning um, has colonial roots as well. There are, many indigenous developments that haven't been recognized in terms of intellectual ownership. For example, and there are some divisions that are grounded in colonial um, practices. For example, to think that indigenous peoples doesn't produce science or epistemologies, and we need certainly to discuss and to make, for example, a prior consultation with indigenous peoples to see how we can make ethical and political commitments in this kind of field. For example, the concept of indigenizing international law is something I developed, but I didn't so. But I did so in dialogue with indigenous cosmologies and with many scholars and thinkers whose contributions I explicitly recognize. That kind of acknowledgement matters because it situates knowledge in relationships, not as something you just extract or repackage.
I think that was a great answer, Professor. I think it's a difficult question to answer. Maybe there's not one right answer, but it's definitely interesting to think about. While engaging with your research, we also read about the concept of the double bind, where which what describes having a soul divided between two impossible mandates. What would it mean to inhabit this double space between indigenous jurisprudence and international law? Do you think international law itself can learn to inhabit this contradiction rather than suppress it entirely?
Yeah, actually, the concept of double bind has been developed quite a lot by Spivak as well, and it's we actually are experiencing double bind practices in our daily life. For example, in my case, the double bind matters because I'm a non-indigenous scholar working on the field of indigenous peoples. So the it is a difficult situation because how I can speak by indigenous peoples without being an indigenous subject. But at the same time, we need to make translations, and the concept of double bind allow us to be creative translators in the way that is not a matter of appropriation of the language of the other, but instead it is a matter of um, try to make improvements of our own culture through intercultural dialogue. Spivak, for example, has been doing that on her teaching practice as well. She decided, to teach one semester in New York in a elite university, and then one semester teaching on the field in India. That is a productive double bind. It's a cosmopolitical double bind, which situates in the same field the possibility to teach in New York, but at the same time to learn from kids on the field in India. So that is a very productive dialogue. It happens the same with Jose Maria Arguedas, the Peruvian writer, who was a white intellectual that grew up with indigenous communities, and for circumstances learned first Quechua, the language of indigenous peoples, and then when he was 12, I think, started to learn Spanish. So he was a double bind subject in a way, because his soul was indigenous, while his skin was white.
Indeed, Professor. Also, as a non-Indigenous scholar working in a field that is saturated with the questions of who has the right to talk about Indigenous knowledge, how has your thinking about your own positionality and research ethics evolved over time?
Um, it has been very challenging. I have learned a lot from indigenous grassroots and intellectuals, and over time I understood that the best way to talk about indigenous laws and cosmologies was through co-authorship. So at the beginning, I was integrating the voices of indigenous peoples through field work in my writing, but in the last 5 years, I have been also promoting um, co-authorship with indigenous leaders, and it has been amazing because it is a practical way to put together the double bind, and to see how we can um, make resemblances and resonances of our our own research. And it has been fascinating because, for example, I wrote a book with two indigenous intellectuals from the desert of La Guajira, and I was expecting an exercise in which um, I was thinking, in contributing in terms of human rights and international law, and expecting a collaboration from them through indigenous cosmologies, and it happens the other way around. It was amazing because Diana Palmar, my co-author, she's a journalist and a lawyer, and because she grew up in a city, she forgot a lot of her own cosmology. So she was contributing a lot in terms of human rights. And because I have been doing field work there, and I have been reading about Wayuu cosmology, I started to introduce concepts that she started to remember again, and she asked me why you know about this. And at the end, amazingly, we wave a double bind, because she, as indigenous scholar, put a lot of effort on Western international law, and I, as a Western scholar, put a lot of effort on indigenous cosmologies. So the trajectory has been quite rich and complex, and have moved from legal pluralism and ethnography to co-authorship with indigenous leaders and multi-species justice. So that mainly is the trajectory.
Correct, Professor. So while we were going through your work, you've described that the current ecological crisis, it is, inseparable from 5 centuries of colonial epistemicide for that matter. But now we see today decolonization, it has become, a fashionable word in international law circles. So how do we distinguish what is genuine engagement with indigenous epistemologies from what, say, a new form of appropriation dressed in decolonial language for that matter?
Well, that is a really important question, and honestly a tricky one. I would like to come back again at the matter of authorship and intellectual ownership to answer that question, because I think that that is where the problem comes in. Extractivism doesn't only happen in territories. It also happens, for example, in our field, in academia. I don't know, to put an example, we have seen hundreds of cases where, for example, PhD supervisors appropriate their students' ideas or research without giving proper credit. That is a form of intellectual dispossession. Similarly, there is still this underlying assumption that academic literature in English is somehow superior even to work produced in other languages, including colonial languages like Spanish. That hierarchy erases a lot of knowledge and reproduces the very dynamics that decolonial approaches are supposed to challenge. So for me, the difference between genuine engagement and appropriation comes down to a few things. Are you giving proper credit? Are you accountable to the communities and traditions you are engaging with? Are you treating indigenous epistemologies as living systems of thought, or just as concepts you can borrow to sound more critical or innovative. If those conditions aren't there, then we are seeing is not decolonization. It is just a new form of extraction dressed up in the colonial language.
Oh, that's a very fair point, Professor. Further, we see that organizations like National Indigenous Organization of Colombia are combining human rights law, non-anthropogenic jurisprudence, and social mobilization into a sophisticated multi-register strategy. As the project of indigenizing international law for multi-species justice moves forward, what do you think are specific milestones or changes in lived reality that will tell you that this strategy is actually working?
There is a huge gap between the law on the books and the law on the field, to put it in legal sociology terms. And what had been happening in Colombia and in Latin America is that we have been experiencing a lot of improvements in constitutional recognition and jurisprudence, but a lot of troubles and problems in terms of implementation, And I think that that is a big challenge for us as scholars, as an activist, which is a very strange thing working on the field of human rights, is that sometimes we put a lot of effort going to the courts and spend years, before the Constitutional Court of the Inter-American Commission dealing with a case. And after, for example, 10 years, we won the case. And then we experienced a very frustrating situation because the implementation of the rulings are a failure. And that show us that law and legal activism is important, but we need something else. And I think that that is why interdisciplinarity it is very important at this moment. We need to make um, productive dialogues outside the legal field in order to think, for example, which will be the best way to implement a ruling. Because it happens all the time, and it's very frustrating. And in a way, my intellectual history has been marked but that double bind as well. I cannot be only in academia because I need action, but at the same time, when I'm doing only action, these kind of frustrations made me aware about the importance of promoting critical thinking. So I think that the double bind between academia and activism, it is key to go beyond um, the improvements that we can make through law.
Thank you so much for this conversation, Dr. Bacca. I think right now, with everything that's going on geopolitically and in terms of the climate crisis, we're living in a moment of multiple compounding crises. So I think conversations like the one we've had today are very important as we go forward, how we think about international law in general. I would also encourage everyone who's listening today to go to the Law School Policy Review blog, where Professor Baka wrote about the University of the Pastos and Kilasingas peoples. It's about indigenizing legal education from the global south, which was also a very interesting piece, Professor. Thank you so much for engaging with us today and for being on our podcast.
Thank you for having me. It has been a pleasure. Thank you.
Thank you.
Thank you so much, Professor. It was a pleasure interacting with you. And it really helps us and helps our viewers, our readers to engage with new perspectives on indigeneity, multi-species justice that are not, mainstream in literature as we read today. So that was really an interesting talk with you today, sharing your perspectives on how you've moved your research towards and how the scholarly discourse is moving towards this. So we also aim to contribute something or some scholarly literature in further while we engage with this concept, while we engage with this domain more. And we truly hope one day we'll be able to have this implementation gap foreclosed, what you was talking about a few moments back.
Thank you.
Thank you so much, Professor.